Now, to speak on alternative dispute resolution mechanism, is it a reality? I would like to call upon stage Dr. Lalit Bhasin, President, Society of Indian Law Firms. Mr. Bhasin.
That was a brilliant address by His Excellency Dr. Abdul Rahman Ulmani. I think that shows that we in India also, I speak on behalf of Indian legal profession, we have to learn a lot. The way you are taking forward the intellectual property rights, the protection, the implementation, and bridging the gap, I think that is remarkable. So thank you for your. Friends, I bring to you greetings from Society of Indian Law Firms, which is the apex body, unique body in the world, which consists only of the law firms. So we have about 130 topmost law firms of India as members. I also bring to you greetings as the immediate past president of the Bar Association of India, which again is an apex body of the legal professionals generally practicing litigation in the courts. I also bring to you greetings from the Chartered Institute of Arbitrators, India branch of which I am the chair. And this is a unique event which has been organized, and I'm very happy to see, by some young people. I got to know that there are 3 young persons, Mr. Abhishek Gaurav, Mr. Pradeep Tyagi, Mr. Vinay Atri, and his brother Gagan Atri, who have been putting in place these events in different venues in different countries, and this is most appropriate to have this particular LexTalk World conference on legal and IP in a place like Dubai. I have put in 61 years of law practice. Therefore, many of you possibly were not born even when I started my law practice in 1962. I see many young people here, and particularly young ladies also, which is a very healthy sign for the growth of the legal profession. This legal profession has undergone changes. When I started my law practice, we did not have any computers or laptops or mobile phones. Our source of information was the libraries, the books, and I still value that. If you come to Delhi, you will find my library starting from the year 1820. The case law will start from that. So that is how law has developed. But is the mechanism in place to provide justice to the people? And I'm talking basically about India, not about any other country, except possibly Pakistan, Bangladesh, Sri Lanka, because we all follow the same pattern of the system of administration of justice. In India, we have nearly 5 crore cases. I'm still not used to converting crores into millions and all that, so you can just convert those, you see. Therefore, are the citizens of our country getting justice when it is delayed beyond reasonable times? No, it is not. Even though our constitution says that we are duty bound to secure to the people of India justice, social, economic, political. But our citizens are not getting. The emphasis is on law, but not on justice. Therefore, what has to be done is to bring justice to the doorsteps of the people. So, how do we do it? People talk about the alternate dispute mechanism. Is it a reality? So people started talking, okay, litigation, 5 crore cases pending, that is not the answer. Therefore, what is the answer? Is arbitration the answer? Speaking about my own experience as an arbitrator, as a professional appearing in arbitration proceeding, and now also as chairman of the Chartered Institute of Arbitrators, I feel that even arbitration has not taken off as it should have. We have judges, retired judges of the courts who monopolize ad hoc arbitrations in the country. Arbitration has become very prolonged, very expensive, and very uncertain because of judicial intervention. So people are now thinking of alternative to this alternate dispute resolution mechanism, which was supposed to be arbitration. What is that? The only answer which we can find is from our own history, going back to the ancient times. Ancient time mean when we had the consensual form of administration of justice. If you have heard, most of you from India must have heard of the panchayat system. Then at the panchayat level, that is the village level, people used to resolve their differences. I would not even call them disputes. Differences in a consensual manner, and the decisions taken were binding on everyone. Same thing was then taken up to the Zilla Parishad, district level, of settling the differences among the people. Then the British came. Even during Mughal times, when we had the Mughal kings there, emphasis was always on justice. If you have heard about Emperor Jahangir, his justice was very eloquent. It was called Adle Jahangir, that is Jahangir's justice. There was nothing about law, it was all about justice. The British came and they brought in this adversarial system, which we have inherited from UK. It is all right. UK is a small country, small population. How can you see you have that system implanted in India, which has a population, you know now, it is, I think, the largest, just next to China possibly. So this 3-4 tier system of first going to the subordinate judiciary, then to slightly higher judiciary, then to the High Court. In the High Court, you have single benches, division benches, then you go to the Supreme Court. Supreme Court also keeps on reviewing its own judgments and all that. So that sort of a system is not suited for a country like India, but we have to live with it because now it is a part of our constitutional framework. It is there. So what is the remedy? Remedy, as I said, is the old form, that is consensual form of justice, which we call, mediation. Mediation means samjhauta, settlement of disputes. That is where your responsibility comes in. You mean the lawyers, the young lawyers, the in-house counsel, the general counsel. Don't take matters, you see, to such an extent that you have to move a court or even to go for arbitration. Try to get the disputes resolved. And that is where we have to learn from institutions like the Dubai, you see, International Finance, DIFC. I have personal experience of how disputes are settled. They are not adjudicated in all the cases. attempt is made to settle those disputes. Same thing is happening in this part of the world, in Bahrain, in Doha, where emphasis is on settlement of disputes. Therefore, alternate dispute resolution is not a reality. It is a myth. It's a lip service. The only answer that is there is mediation. So, Chartered Institute of Arbitrators, we have started different courses for training of not just the arbitrators but also the mediators. And that is proving to be a big success. It has been adopted by various high courts of the country, including Delhi High Court. We have mediation centers now. Therefore, that is the need of the hour. We have to learn from countries like UAE, like Bahrain and Qatar and all that, as to how they are tackling, you see, this growing menace of litigation and dispute resolution. I'm very heartened to see, you see, so many young people here. Therefore, I'm again appealing to you, and particularly the General Council, that try to develop negotiating skills to negotiate with your opposite side, whom you think you have a dispute with, and you will find that, you see, there would be like settlement. Therefore, answer would be settlement and self-regulation. I don't believe in having too many laws. In India now we are having a mediation bill which is pending. I don't know whether it will serve the purpose or not. But there has to be a voluntary effort on the part of the corporates, on the part of the chambers of commerce, and on the part of the legal professionals to encourage, promote settlement of disputes. That is the only way out. Thank you very much.